Hi everybody, my name is Jocelyn McKenna. Some of you would have heard me yesterday giving you a little bit of a run through of the legal background in Ireland to where we are now, and I'm going to introduce my panel here. You've heard earlier today Mike Gaffney. Mm-hmm. Mike, good to see you again.
Thank you.
We met in Toronto 2 years ago.
That's right. And
at that stage, Mike was the trailblazer. He was the guy who did it. We had him up on the platform. We should have put a crown on your head. And then beside me here, Kevin Kelly. You've heard him also earlier today. He's got a bit of a tan. You'll like to know he just flew in from Indonesia. So he will be helping us look at the Irish situation here, because we have obviously we're in a state of flux. We've come a long way from Toronto. 2 years ago, we have brought the focus of attention in Parliament here onto the subject, and we're very pleased with that. So on my right, Jocelyn Downie has already spoken to you earlier on today about the developments in Canada with MAiD, and we'll be looking more closely at how that can impact on legislation generally as we consider its introduction here. And then on my farthest right is Simon Mills. Now, you haven't met Simon yet, but he was involved in the Fleming case. He was one of the lawyers who presented the case on behalf of Marie Fleming. And that obviously for us is a platform case, because it brings us to where we are now through the judgment that was delivered by Susan Denham in the Supreme Court. I'd like to begin perhaps, if I could turn to Mike, because you're at a stage now where you're reviewing, you got a 5-year review. Has that been implemented yet?
We actually had a 6 months operations review, and we have a 3-year review, and then every 5 years after that, which I think is really important. So in 2025 will be our review, and if going back to the slide where I said we have the operations, the scope and potential scope, gives us quite a wide range that we can potentially have some amendments that will have the legislative facility or know-how to actually change those. Where in some of the other Australian states where they are focusing on operations, they possibly, the naysayers will say, well, you can't go there because you don't have that in legislation. So from our point of view, so then after that, like most acts, it's every 5 years.
But you're making a distinction now between the operational review that took place and has been taking place with the legislative review, is that right?
Well, it's written into legislation, so we wanted 6 months to see how it was working, and then 3 years from when it came in implementation, we wanted to have a review of the whole Act, and the operations is part of that, and then every 5 years after that, so that it's an evolving feast. And we've got people in my state that want to say, we should be doing this and we should be doing that. And I say, look, just stay calm. There's a lot of other people working in that space. We're better off just to hold our fire a little bit. And so, for example, next week in Parliament, I'm introducing a notice of motion about the Go Gentle report that just came out to raise the issue. And then in March of next year, I'll raise the notice of motion for the annual report to raise the issue again, so it's on the people's minds, so that, and then I'll say, oh, and by the way, we've got a review coming up in October. Let's do something with that. So it's a way of drip feeding the information through, and not having people startled by what's going to happen. It was, I think that was what enabled our legislation to pass with, and I'll just shut up in a minute. And so what happened when we actually had the debate, it passed in the upper house and gone to the lower house, when it had the debate, even the people who voted against it and spoke against it felt validated that they had a good discussion, it was a good parliamentary process. And I mean that in all respect, just because it got through, even the ones who thought, oh, that passed felt as though that they had the opportunity to speak. And I thought that was quite uplifting for our Parliament, because that doesn't happen very often.
Before I turn to Canada, just one thing, in light of what you just said, do you see changes taking place?
Oh yes, Yes, yes. I think, the other Australians have mentioned it, the residency thing will change because now you have all states, one territory and another one, so you don't have to be protective of the border. We didn't have enough doctors and nurses that we could allow people to come in as a tourism state, so that'll change. And with that, you only need a driver's licence in Tasmania to prove that you're a citizen, a driver's licence, or you've enrolled to vote, or you've got a lease on a thing. So it's not the whole passport and a birth certificate and that sort of stuff. We got rid of that. So that was where it was handy coming in third. We had no gag clause, as was mentioned before. So we were able to introduce things that were different to the other states. And because we're a smaller state and people have a little bit more trust in what we're trying to do, it was more of a conversation. So when I stood up and said, well, we should be doing this or that, other people were quite, well, Michael wouldn't be doing that if he didn't think it was right. Do you know what I mean? It was like, it was a nice conversation to be in, a nice place to be in.
Okay, we might come back because we might micro-analyse a little bit what those changes might be. I want to turn to Jocelyn now, and having listened to Mike and listening to what he has to say about the process of review, I'm intrigued by the Quebec experience because it seems like it's maybe a sign of things to come. But can you give us a little background on the review process in Canada? Not that I want you to repeat everything that you said earlier on, but maybe you could draw attention to some of the aspects.
Yeah, so it's worth mentioning what happened in Quebec in terms of process, and because it partly explains why MAiD has been received differently in Quebec and is in some ways more progressive. And that is that they were catalyzed actually by clinicians saying, we need to think about this, we need to talk about this. And so their National Assembly established a process that was deeply consultative, engaged the public for several years in conversations. And one thing that was very revealing, I testified before them, the committee, the special committee, right at the very beginning, and this is something that would never happen in the federal parliament, which is, I got through the entire session with them. I think we spent an hour and a half together, and I could not have told you what party any single person was from. No partisanship, unheard of. They were just inquiring. They were genuinely asking questions. They were trying to figure out the best way to do it. So it's an admirable process. Yours was an admirable parliamentary process. Federally, we have had what is now toxic. And so I'm now, like, that's why I'm in court now, because court doesn't get toxic in the same way. But our parliamentary process of revisiting, because they keep being forced to revisit by the courts, it's toxic. It's just yet another opportunity for the opposing sides to battle each other, and they're battling through the media and in the public, because that's how you reach politicians, as opposed to how you reach courts, where you develop your solid evidence and argument.
This thing, you have about 5 steps forward and 3 steps back, and then another 3 steps forward and another 2 steps back. That suggests conflict. And that conflict is between the legislature on the one part and the courts on the other?
I'd say the conflict is in the conversations in Parliament and through the parliamentary process. When you have special committee, have hearings, they bring in their people, it's become hyper-politicized and partisan. So that's where it's conflict. I wouldn't say the back and forth court to Parliament is conflictual. That is a part of our system, because our Supreme Court can just strike down the law, and then the federal Parliament can decide what it wants to do and how it wants to respond. And it doesn't necessarily just cut and paste, as our Attorney General said at one point, cut and paste from the court decision into legislation. So an interesting example is in Canada, the Supreme Court of Canada struck down our abortion law. And the federal government just decided not to do anything. You don't have to respond. And so abortion is a medical procedure in Canada. It's regulated as in any other medical procedure. It's not in the criminal code. With MAiD, struck it down, and then the federal parliament said, okay, we're putting in a regulatory framework. They narrowed the eligibility criteria from Carter. So we had to go back to court and fight it in Truchon. Truchon struck it down. Federal government came back, put in place, narrowed it again. Now we're going back to court. So it's not, I wouldn't say it's directly conflictual. It doesn't feel conflictual between Parliament and the Supreme Court. It just feels like a tug of war, ping pong. But for us, we feel like it's conflictual because they're taking away what we're winning in court, then we have to go back to court and fight again to get it, and then they take it away.
The area of mental illness and dementia, and the idea of an advanced directive that would enable somebody to use MAiD seems itself to be quite controversial in view of the fact that there's a federal law that prohibits it, and yet you've got the prosecutor service in the state that seems to be independent of the criminal code. That sounds like a paradox to me.
Yeah, welcome to Canada. It's federalism. So the criminal law is federal. Australia, it's state-based, right? So you don't have the same kind of conflict. So the criminal code is established federally, but the administration of justice is done at the provincial territorial level. They have the power over that. And so the public prosecution service is provincial. And so what can happen is there is here too, everywhere has discretion around charging. And the UK put in, they have prosecutorial charging guidelines around Keir Starmer did it, right? Years ago. Not quite to the same effect as this one, but so the prosecution service can issue charging guidelines. They have principles. It has to be that it's not in the public interest, or you don't have any chance of success. You're not going to win, so you're wasting court resources if you're just constantly going to have juries say not guilty. So it makes sense and works normally. What I think you've got your finger on is that has this gone too far? Because in a certain way, when you have the Public Prosecution Service say, we will not be charging, if you breach the criminal code but you follow the Quebec law, we won't be charging, you're basically vitiating the criminal code provision. And one could argue that that is extra, that is ultra vires. They don't have the jurisdiction provincially to completely just knock out the criminal code. They're not sort of doing something which is exercising discretion at the margins. It really is just saying, we're ignoring you. The thing is, this is the politics of Canada, this is Quebec. And Quebec gets allowed to do a lot of things that the rest of the provinces and territories don't, because it is distinct, it has a history, and it has a lot of political power in that. So I could make the argument that they don't have the jurisdiction to do it. They've gone too far with those that guidance document, but the federal government is never going to call them on it. So there won't be a court ruling that they can't do it. Yes. So it's going to sit there.
Okay, we had an interesting session during the week on Thursday, and Sean Davidson, you would have been there, reported that he had been arrested and that he's looking forward to a prosecution in the UK. I'm going to turn to Simon on this one because it seems we're talking about the criminal code here. Voluntary assisted suicide is a crime. So that focuses attention now on the Office of Director of Public Prosecutions, in whose charge it's placed, as we listened to Jocelyn, to enforce a law, or in fact pursue a crime, or the commission of one. How do you see, and I'm not sure if you're familiar with Sean Davison's case, he assisted a death in Switzerland, and he was arrested and now faces the consequences of that. And I mentioned in my presentation that Gail O'Rourke case was the only one in Ireland that I could find that went to court, and that didn't. The jury was directed to make a return of not guilty. What are your thoughts on where we stand with the DPP as we go forward in the interim while legislation is being contemplated?
Yeah, I mean, what Mike and Jocelyn have had to say is quite interesting in that it points out that there are, to some extent, three strands to all of this, and to thinking about it, analysing it, and acting upon what society as a whole ends up thinking about assisted dying. There is the pure legal process, that is to say what the courts decide. And to some extent, that's quite easy, because courts can declare, presumably in accordance with the law and presumably for good reasons, although not always, what they believe the law to be. But then on the political and administrative side, you've then got to implement that in a society where there may well be, whether you like it or not, reasonable disagreement about what is right or wrong, reasonable disagreement about how a legal decision should be implemented, and reasonable disagreement about what form legislation should take. And very often it is the fear of what the legislation that will look like that is a real obstacle to change happening. It happened here in a debate about reform of the abortion law many years ago. And one of the first things that I did, for example, when I was asked to speak to an Oireachtas committee, was to turn up with a draft law and say, look, I didn't tell them I'd knocked it off in a lunchtime the day before. I said, look, this isn't easy, but it can be done. And sometimes overcoming that fear is important. But because politics is the art of the possible, that sometimes speaks, I think, to the tension that Jocelyn and Mark have identified, which is the idea that courts have said something can be done does not necessarily make it politically possible or politically easy. And then once you are stuck in the terrain where government has so far decided not to legislate, has on its table a recommendation from an Oireachtas committee that they should legislate, albeit with dissenting voices that represent a portion of the Irish body politic that remains important when votes come to be counted this November, when there's likely to be an election. And then within all of that, you have the question of how is it that you police an area that is the subject of reasonable disagreement, uncertainty, and moral arguments that some prosecutions will be wrong. But also, it is important to keep the legislation on the books because there will be unanswerable moral arguments that certain prosecutions must take place and that certain people must be convicted for doing things that are outside both the legal and moral code. But a short answer to your question is that it's absolutely clear to me that there are prosecutions that could have taken place that have not taken place, and I'm aware of some. And it is clear that there is unease about the potential breadth of the law. And I think that the law is there, because even after reform of the legislation, that law will still be there, but is, I think, being regarded in a certain way by those charged with achieving the possible while running a humane and pluralist society, that certain prosecutions haven't taken place. Now, I don't know if that is the answer to your question. I hope to God it is, because it's taken me 5 minutes.
Well, I tell you, I'm kind of just, my own thoughts are going centred around what's happening perhaps in the UK. But very much in part of what's we're talking about is Dignitas and the route to Switzerland. Because like we heard earlier today from Sylvan, when he spoke about going to Switzerland has a meaning on its own. When you say that here, going to Switzerland, in the O'Rourke case, it was the travel operator was the one who alerted the police, because going to Switzerland, why are you going to Switzerland? Well, I have a friend in Dignitas.
And you could always have said, my friend is a terrible skier and I don't anticipate her surviving. But that excuse didn't occur to her.
We, the knowledgeable, would know what to say if asked the question. It's those that don't, I suppose. And I'm just trying to work out the idea of the Starmer rules, where you might lay down an idea that in certain circumstances we would consider prosecution, to bring certainty to the idea that using Dignitas as a route.
That was flagged. Sorry, I think I can see it maybe a clear. That was flagged by the High Court in the Fleming case as being a possible route, but it was reasonably comprehensively slapped down by the Supreme Court, while also leaving open the idea that if the Oireachtas wanted to facilitate an arrangement whereby such, if you like, prosecutorial rules were permitted, it'd be open to them to do so, but that they did not perceive the current structure of the way in which prosecution decisions were taken in this country, as opposed to the UK, as allowing easily for that kind of arrangement.
Okay, I want to turn now to the idea of where we are in Ireland. As we approach the new, let's say, I'm going to say, I mentioned the death of the current administration, because we're coming to the end of a cycle. And we have elections to look forward to either this year or maybe early next year. And that's when we're going to be looking at a program for government that will include assisted dying in its in the program. And as we do that, Kevin mentioned earlier on the recommendations of the Joint Oireachtas Committee that looked into this over a period of time, and at which Simon, Kevin, and myself and Janie all testified, as did Greg Mewett and others in this room. But it was all about the safeguards, wasn't it, Kevin? And it's really a matter of designing a law that works, listening to what we've been listening to hear how it works in other places. Like listening to the frustration of Gary Payendi yesterday, talking about the paperwork that sometimes goes with the process of checking and double checking, understanding the vulnerable patients, the concept of coercion. What I want you to reflect on with us is, and also bearing in mind that we have a draft bill at the moment in front of the House, a private member's bill. How do you bring us to the next level where we have to encourage our politicians in drafting fresh legislation?
I suppose it's a bit of a tricky situation at the moment, because with the new election, it's unclear whether or not the report and the recommendations will be as binding on the new government. But I think it's been great today to see a kind of how safeguards operate in other jurisdictions. The one proposed by Ireland is probably on the more stringent and kind of exclusive end of regimes, with the kind of the 6 months for someone with a terminal illness, or the 12 months for someone with a neurodegenerative illness. It's unclear where those numbers came from, or if they were just copied from Australia and New Zealand, or if much thought actually went into them. But I think it's really important that they design a system that's more inclusive than exclusive, but it's unclear whether, well, or how these recommendations will fall through into the next government. But in terms of the safeguards we have at the moment, they do seem to probably line up with what the Supreme Court asked for in the Fleming case, that they strike the balance, but perhaps it's not as balanced as in favour of those seeking treatment as opposed to excluding them. So it's difficult to navigate where it will end up, but I suppose the recommendations are what they say for the time being.
Well, the impression I get, certainly coming away from a conference like this, and I know the two of us will be chatting and looking at those recommendations, so that I want End of Life Ireland in particular to give its response. And I've said that we'd wait until after this conference so that we could give a measured view. And I'd like to think that we could do something that would be patient-centric, that wouldn't necessarily pander to the fears of the Conservatives within either the medical or political area. How do you feel that can be accommodated if that's what we were going to do?
Well, I suppose any election you can leverage things you want for a vote. So I suppose it's very important that those who are voting speak to the local TDs who come around knocking on the door to stress that that's something they're interested in. But I suppose other than that, it's a bit difficult or unforeseeable how things will unfold.
Yeah.
Could I just add in just one other thought that occurred to me just from having read the report and having been at the committee, which is, it is absolutely true that they made a recommendation and that they talked about safeguards, but there's something else I think underpinning it as well, and I think that comes clear from the report and was clear from the questioning. And it's, to borrow a phrase from another area of huge social concern, it's about a just transition, which is that if society is to accommodate MAiD, going back to something that Greg was just saying, it's something that falls to be integrated into a properly resourced, justly provided healthcare system that includes proper provision for end-of-life care in all of its facets, for those who choose to avail of MAiD, for those who choose not to, and in particular, properly resourced palliative care, of which, and I agree with Greg here, MAiD is or should be one facet. But that idea, I think, of it being not just about introducing assisted dying in isolation as a bolt-on to a malfunctioning Irish healthcare system is, I think, a dangerous response. I think it has to be part of a holistic approach to end-of-life care that is properly resourced and properly structured. And I think that comes across as well. And to some extent, I think that may be one of the bigger obstacles in the current climate to moving it on, rather than a philosophical objection to the idea of MAiD itself.
Yeah. I'm thinking, as you're speaking, Simon, about the differences between the medical approach and the legal approach, and Kevin mentioned earlier on about the division between or the separation, I should say, between the palliative care on the one hand and the idea of voluntary assisted dying. Then that returns to you, Jocelyn. You mentioned something also about that impact, and I know Greg gave us a dissertation earlier on this question, but from a legislative point of view, how is that handled in Canada?
So part of the strategy in advocating for assisted dying in the parliamentary process was to call for parallel tracks. It was to say absolutely allow for for MAiD and increase access to palliative care. But one key argument was to say, and it came out in the court in Carter, so we were able to rely on in Parliament as well, is to say, do not hold an individual hostage to systemic failings. So don't say, wait till you got your palliative care sorted, and then you can have MAiD. No, it has to be at the same time. And then one of the things you do is the politicians are watching where the opposition's coming from. Some of it's coming from palliative care, some of it's coming from some disability advocate groups. And so they strategically say, we're increasing our funding to palliative care. We care about quality and access as they're doing MAiD. So get them to see that they're twinned in their political interests. We see that they're twinned in terms of good care.
Yeah.
And then they come along together. But you have that underpinning. The language of don't hold individuals hostage was effective. And I think it's right. I mean, don't hold individuals hostage to systemic failings.
Like night follows day, one will follow the other anyway.
Yeah.
This is the funding and support. I would check. Go ahead.
I wouldn't mind making a comment on that one, because I think I mentioned in my presentation that in 2009, when we came out with Dying with Dignity, that palliative care up in arms about it. So I knew that was an issue I had to deal with. So I went to every meeting, every conference, every time Palliative Care Tasmania had anything on, whether it was a cocktail party, whatever, I was there. And so, especially, but the interesting thing is that when I did my PowerPoint presentations, I contacted the CEO of Palliative Care Tasmania. I said, look, it would make it very powerful if people in Tasmania understood what Palliative Care Tasmania's position was. And I can nearly quote this because I heard it a lot of times. I think she said, rest assured, Palliative Care Tasmania, while it may not have an opinion regarding voluntary assisted dying, that Tasmanians will receive palliative care all the way up to the event and beyond. So what that went out to Tasmania was, you will be eligible for palliative care if you choose the voluntary assisted dying pathway, and that's the reassurance that the people want. They don't care about legislation, they don't care about what doctors and nurses think that much. They just wanted the reassurance that they would be eligible for that if they chose that pathway. And I thought, because she was willing to come out and do that, and I took that round to on the PowerPoints, that was a very strong message for Tasmania, saying that our peak body of palliative care in Tasmania, and the resultant of that was the mainstay said, well, we'll put more money into palliative care, we'll put more money. When it got passed, they had come out and said they'll put more money into it. So that was the result. So the health minister at this stage, who is anti, had already said we'll put more money into healthcare. So I think that's consistent with all legislations that I'm aware of, that more funding has gone into palliative care Tasmania because they recognise the weaknesses in it.
It also makes the choice that we're all here to talk about much more meaningful if it's a choice between excellently resourced palliative care and assisted dying.
Yeah, and it was something else that Brendan O'Shea said yesterday about over-medicalising. So if you've got too many people in the operating theatre, you've got to say, you were overdoing this because the patient's going to be dead anyway from some other source, but they're busy fixing a foot or something. But whatever about all of that, it's partly to do with, and it was something that I picked up on the Victoria report, review report, which was training to the highest possible level, which is also mentioned, Kevin. And I'm just thinking in TAS, when you go to your amendments, will that be addressed? This question of having to go to the highest level, how qualified should a person be to decide that you have to have a psychiatrist as well as a geriatrician or whatever else is going to be there to decide whether this person is eligible or not? Is that part of a strategy?
Yeah, it is. I mean, it's written into our. I must admit, it was an easy. It sounds as though it was an easy pathway because there was OPC Robin, who was the drafter, and there was me sitting at a table working out a 160-page bill. I didn't have to go to all these different departments or different anywhere else. It was just two of us. I did when we did the debate in the chamber. I did ask a friend of mine to come along, and could he wear a suit and tie so he looked like he was a lawyer? That helped. That did help. And so I trust in the process. I trust in what we've got in the legislation. So the question you asked there about is that possible and whatever, I think it is. You know, I have faith in legislation because I think it reflects the will of the Parliament, which should reflect the will of the people. And so whilst there are, and the other one I'd say is, Andrew Denton said 80% of something is better than 100% of nothing. And so in my original draft bill, I had the issue about the minors, and I had the issue about pain thresholds, and I wanted the committees to go out and research that and come back to the Parliament. However, one paper picked up on it from the mainland, said Gaffney wants to kill children, was the headline. And then I thought, this is going to turn some of the politicians, it'll give them an excuse to not vote for this legislation. So I withdrew the mature minor, I withdrew the pain one, thinking that I'm better off to get the legislation there, and then in the event, in 3 years from that, that's when I bring that back in, and that's when I do the groundwork to ensure that those two aspects of my original legislation get a better hearing.
Fair enough.
Can I mention something? Just in relation to the idea of progress through evolutionary steps. We did actually achieve something in that vein, which I think is important to carry forward. So when we had the Coercion decision, that meant that the Parliament was reopening the criminal code because they were going to take out natural death has become reasonably foreseeable. At that point, they did do a huge consultation. There was more public input than any other survey questionnaire they'd ever done, flooded with it, and they went around the country, did roundtables and so on, and they listened to the clinicians and to the patients and to lawyers, and they made changes. That's when we went from 2 witnesses to 1, because people pointed out it was a real barrier to access, and why do you need 2 witnesses? We got rid of the 10-day waiting period for track 1s because it wasn't protecting people. And really importantly, we got the final consent waiver that way. Because Audrey Parker, and this goes to strategies, a single person out there speaking, and you've had family members speaking, it's so important. She spoke out about the fact that she had breast cancer, she had brain mets, she was at risk of losing capacity, she wanted to live through the holiday season, it was her favorite time of year, this was fall, but she knew she was at risk of losing capacity. And because she had to give express consent immediately prior, She died on November 1st by MAiD of that year instead. And she spoke out and said, what is this? And they listened, and they changed it, and they put in final consent waiver. So it can happen, and I think I have more optimism for it happening for you because of the foundation that you've laid there of the process within Parliament and with the public being involved. But even in our somewhat dysfunctional system, we did make change that way. So I think get it as good as you possibly can, because change can be really, really hard. Don't just think, well, let's go for what we got. Get it as good as you possibly can, but don't give up on the hope of change, and build the process for change in. Because, I mean, final consent waiver is a big change.
Now, on that point, that's food for thought, and I can hear the sound of stomachs rumbling, which suggests food of a different nature is also required. Thank you, ladies and gentlemen, for your attention, and thank you to the panel.
Thank you.